versus Robert Geese, 26T884. And if you'll come on up to the podium. He appears in the courtroom, and the district attorney, Mr. McGraw, appears for the people. So, Mr. Geese, are you going to be hiring a private attorney? Do you want a referral to the public defender, or are you going to be representing yourself?
Your Honor, do I have standing to speak?
Yes.
I appreciate that. It's important to me that I stay respectful. I come in peace as a non-belligerent. I would like to read this into the record, if I may.
Sure, go ahead.
First, Your Honor, respectfully, for and on the record, I am Robert Eugene Geese, a man of the Union, a natural person, as said, a non-belligerent or enemy of the state, and I occupy the office of executor and co-trustee for the Noli Me Calcari Express Trust. I am here propria persona in that regard by special appearance only, not generally. Further, I am of the age of majority by both age and averment sui juris on the record in Weld County. I deny that I am a U.S. citizen, nor do I claim to be a sovereign. I deny that I'm a federal 14th Amendment citizen, a corporation, or a statutory person. I'm a natural, freeborn national of the territory of Colorado, known as a Coloradan. If I may, I would like the court to take judicial notice that the written record thus far is incorrect. As said, I am here propria persona. I am not here pro se, nor am I here pro per. It's important that that be documented and on the record. I have submitted a motion of discovery and an affidavit of truth. Has the court received and reviewed those documents?
If you want to request discovery, you need to do that through the district attorney's office.
I've done that.
Okay.
And the documents are recorded. Sir, did you?
I have received your request for discovery. It is being processed at this time, sir.
Okay. With that in mind, I don't know how this court can proceed without the affidavit being rebutted, answered, and this discovery being taken care of.
That's not how this works. So the court is not the one that goes through the discovery. If you want to talk to the DA regarding plea offers in the case, I'm happy to set over for you to do that. If you're going to hire a private attorney, or if you want a referral to the public defender, I'm happy to set another day for you to get that done as well.
Would you like to discuss?
Welcome back, everyone. Today's courtroom footage features not one, but two defendants who reject the legal system in remarkably similar ways. They don't call themselves sovereign citizens anymore. Instead, they insist they're natural persons, freeborn nationals, 14th Amendment citizens. The labels may change, but the courtroom strategy is almost always the same: challenge the court's authority, redefine legal terms, refuse to acknowledge standard procedures, and hope the case somehow falls apart. Our first defendant, Robert Geese, walks into court facing relatively straightforward traffic-related charges. Instead of focusing on the evidence or preparing a legal defense, he immediately launches into a lengthy declaration about trusts, citizenship, executive authority, and his unique legal status. The judge, however, has heard variations of these arguments countless times before. Her job is
26T884.
And if I may correct the court, the last name is pronounced Geese.
Geese, sorry about that.
As in Canada geese. Yep, that's okay.
Okay. Mr. McGraw?
Yes, after speaking with Mr. Geese, I advised him of the offer on the case. It is his plan to plead not guilty and set for trial today, Your Honor.
Okay.
Well, if I may,
I apologize.
respectfully, I do not plea. I don't know how I can plea. And I object to and would not consent to a plea being made for me.
Okay, so how do you want to proceed?
Well, we'll go ahead with setting up a trial.
So if you want a trial, that means that I will be entering a not guilty plea.
I understand that. I respect that. I will object to it, and I don't consent to it, but let's proceed.
All right, so I need to go through an advisement with you regarding your right to counsel. Do you understand that you have the right to be represented by counsel in your case?
Yes,
Do you understand that if you cannot afford an attorney, one would be provided to you free of charge if you qualify financially for the public defender?
I am here propria persona.
Do you understand that the charges against you in this case are driving under a revoked license and careless driving? They're both class two, I'm sorry, the careless driving is a class 2 misdemeanor traffic offense that carries up to 10 days to 90 days in the county jail. The driving under revoked license is as a class A traffic infraction and carries a possible fine. Are you under the influence of any medication, drugs, or alcohol that would affect your ability to think clearly?
No,
Do you wish to consult with the public defender before you make a decision to waive your right to an attorney and represent yourself?
no, I do not, and I do not waive my right to trial by jury.
Um, have you ever studied law?
I don't know how that is relevant to the case, Your Honor.
I'm trying to make sure that you're knowingly, voluntarily, and intelligently waiving your right to counsel.
I am.
Have you ever represented yourself in a criminal action?
I have.
Here, you can already see the first major disconnect. The defendant genuinely believes that filing affidavits, trusts, and discovery requests somehow prevents the court from moving forward. But that's simply not how criminal procedure works. Discovery is handled between the prosecution and defense under established court rules. It isn't automatically controlled by a defendant declaring that an affidavit has gone unrebutted. It is how calm the judge remains. She doesn't mock his terminology or argue about whether he's a natural person. Instead, she keeps redirecting him toward the only issues that matter today. Does he want an attorney? Does he understand the charges? Does he want to negotiate with the prosecutor or proceed to trial? Experienced judges often avoid getting pulled into philosophical debates because doing so only
Do you know how to request that witnesses be compelled to appear on your behalf? To subpoena them?
If you're asking whether I know administrative procedure, I wonder, Your Honor, is this a court of equity or is this an administrative court?
So do you understand that if you represent yourself, you're on your own? I can't tell you or even advise you how you should try your case.
I am here propria persona.
You know that you have the right to represent yourself, but by doing so, you could take a great risk of not properly presenting your case. Do you understand that you will be required to abide by the Colorado Rules of Evidence and the Colorado Rules of Criminal Procedure? And do you understand the defenses to the offenses by which you're charged? Do you understand that an attorney would be familiar with defenses and requirements to raise such defenses on your behalf? Do you understand that you must proceed by calling witnesses and asking them questions, not arguing or making speeches, but asking appropriate questions, and that you will not be permitted to tell the jury matters that you wish for them to consider as evidence during the examination of other witnesses? Do you understand that it would be much easier for an attorney to contact potential witnesses, gather information, and question witnesses, and to present your case than it would be for you? All right. At this point, I'm going to find that you are aware of the rights that you have and that you're giving up by waiving your right to counsel. You are not choosing to cooperate with the process, But at this point, the court's going to find that you've knowingly, voluntarily, and intelligently waived your right to counsel. We'll go ahead and enter a not guilty plea and get the case set for trial.
I object, Your Honor.
You're the one that asked me to set it for a trial. If you don't want it set for trial, I'm happy to set it for something else. Do you still want it set for a jury trial?
Yes.
Okay.
Is incredibly important because many viewers misunderstand what's happening. The judge isn't questioning the defendant about whether he committed the offense. She's conducting what's known as a waiver of counsel inquiry. Before someone represents themselves, the court has a constitutional obligation to ensure they understand the risks involved. That's why she's asking about legal experience, courtroom procedure, and whether he understands the disadvantages of proceeding without an attorney. These aren't trick questions. They're safeguards designed to protect the defendant from making an uninformed decision. Ironically, the defendant's repeated attempts to avoid straightforward answers actually make the judge's job harder. Every time he sidesteps a question or responds with sovereign-style terminology, the judge has to gather enough information to prove that any waiver of counsel is knowing and voluntary.
Third, I'll order that motions be filed on or before May 4th. That'll also be the deadline for endorsement of witnesses and defenses. We'll set a half-hour motions hearing, trial readiness, and jury trial dates. And let's see what dates we have.
Motions hearing at 3:30.
Okay, June 15th at 3:30 for motions.
Trial will be July 29th.
Okay, July 29th at 8 o'clock for jury trial. Okay, July 14th at 11 o'clock for trial readiness. Trial readiness will be the last day the court will accept any plea agreements in the case. The court will issue a written pretrial order, and we'll print an extra copy for you today so you have those. Be sure to look because there are some additional deadlines and information in there about doing jury instructions and things like that.
Inevitable conclusion of hearings like this. After giving the defendant multiple opportunities to participate, the judge reaches a legal decision based on his conduct rather than his rhetoric. He wants a jury trial. A jury trial requires a plea. If he refuses to enter one, the court enters a not guilty plea on his behalf. That's standard criminal procedure designed to preserve, not eliminate, his constitutional rights. What's interesting is that the defendant keeps objecting while simultaneously requesting the very process that requires the judge's action. In other words, he's asking for a trial while objecting.
People. Mr. Leffers appears in the courtroom but refuses to enter the well. I do remember this from the last time we were here last week. The court had removed the attorney of record and indicated that it would have a new attorney appointed. Mr. Leffers, that has not happened yet. We're still waiting for an attorney to be appointed for you, just so you're aware of that. All right?
Your Honor, is the court going to reset the probable cause conference to next week?
We will, but it looks like Mr. Leffers is digging through some stuff here. What do you have, Mr. Leffers?
Well, I should go through that.
Mr. Leffers, before you start, I gave you a lot of time last week, so I'm not going to give you very much time this week. So if you're planning on giving the court a history lesson in maritime law or self-governance or any of that, I'm not going to have that today, okay?
So I have to stand up for my rights, otherwise my rights are forfeited by my subjection, and I will not do that. Your Honor, are we on the public record?
We are.
Is this a court of common law or admiralty law?
Mr. Leffers, I am not doing this today. I've already told you that. We're not going to go through this.
I move the court to take judicial notice of your oath of office to the Michigan Constitution as ratified without subsequent amendments on the United States Constitution. What say you, sir?
I addressed you last week about about the oath I took. I confirmed that you had a copy of my oath. I confirmed that.
Thank you. Your Honor, moving forward, Article 3, Section 2, Clause 2 of the United States Constitution says that when a state is a party in a case involving a citizen, that state, the Supreme Court, has original jurisdiction. The state has a conflict of interest. You cannot unbiasedly represent yourself in the state. The state cannot be a victim. Also, we have been made aware that there is some judicial bonds that may have a monetary value, which clearly gives the state an interest in the outcome of the case, which once again is why Article 3, Section 2, Clause 2 of the Constitution exists.
Ends almost exactly how experienced courtroom observers expected. Despite all the references to trusts, citizenship, affidavits, and special appearances, none of those arguments changed the legal posture of the case. The defendant still faces the same charges, the same deadlines, and now the enormous challenge of representing himself against trained prosecutors. Representing yourself is a constitutional right, but it's also an enormous responsibility. Criminal trials involve rules of evidence,
Any accounting on the bail bonds, performance bonds, and I am not a 14th Amendment citizen. I am a Michiganian, state national. I have corrected my status. I have spent a year doing it.
What do you mean by that? No, you tell me what you mean by that. I don't need you to look at paperwork. You said you corrected your status, so what do you mean by that?
Upon finding out about jurisdictions, 14th Amendment citizen is bound by your jurisdiction, sir. I am not a 14th Amendment citizen.
What are you?
I'm an American state national.
And what is that?
That is a man or woman born to the state in the territories of the Confederation of the Republic that made up this wonderful place and all the rights and freedoms that we all have that have been abrogated through policy and procedures.
So are you claiming you're a citizen of the Confederacy from after the American Revolution? And when I say the Confederacy, I mean after the American Revolution and before the US Constitution.
No, sir, this predates even that.
Okay.
I am a living man that follows the Creator's law, the supreme law, the law of the land, which no policy or procedure can abrogate my rights or immunities.
So then how are you relying on the Constitution to say that I don't have jurisdiction if you don't believe that you're subject to that?
Yes.
Supports it.
The second judge handles things. Unlike the first hearing, this judge immediately recognizes where the conversation is heading. Before the defendant even begins, the judge references maritime law, self-governance, and constitutional lectures, essentially signaling, "We've already had this discussion, and we're not repeating it today." That